or Transport Corporation, NHAI, constraints will be there, and we are there to deal with the constraints, deal with it in such a manner that it doesn't affect the progress of the establishment or the progress of the, the, the target, the goal to be achieved. See, for instance, I will tell you, what is the purpose of this seminar? How to deal with these constraints. See, let us take it. See, because every public sector enterprise is, the purpose of it is to serve the public at large in such a more effective way and in a cost effective manner. If a transport corporation is there to operate the buses vis-a-vis the private operators, you get at the very less cost the travel from one place to another, and thereby the public at large are benefited. So it's, after all, it is for the benefit of the public. You take, for instance, the national security, the existence of the armed forces. Even there, it is one, I would say that it is also one of the public sector enterprise, I would say, because the personnel, army personnel who toil for our nation, they need very many support. It would involve civil work, transportation, provision of food, procurement of arms, ammunition, any other requirement for the day-to-day effective working of that institution. Therefore, it is imperative that the supply and disbursals, the procurement and its disbursements are carried on in such a way that there is no flaw in its operation. So, these basic features are there in every other corporation. Oil corporations, excavating industries, transport corporations, road laying, every other public sector enterprises, these basic features are present. Therefore, these topics which have been clearly set out for this national seminar, I have found that under the leadership of Dr. Acharya, it has been very meticulously coined. There are seven topics which I have found: management of turnkey and EPC contracts, management of public procurement, framework of tendering and contract management, where common issues and solutions are to be examined, management of contracts and competition issues, emerging trends in contractual dispute resolution, management of dispute resolution through conciliation and arbitration, with legal updates on commercial courts, commercial benches of high courts. Therefore, every one of these areas are to be addressed, has to be examined minutely and with absolute concentration when the experts deal with these issues, topics. For instance, if you take up management of contracts, we heard Dr. Acharya also, as well as Dr. Chaubey saying, the first major issue is to be addressed is the terms of the contract. Very, very important, because in the course of dealing with these arbitration awards which came before us, we have found that there were, I don't want to use the expression carelessness, but there were certain deficiencies in expressing the exact requirement of the terms of the contract. The terms must be specific, clear, and as Dr. Acharya put it, it should be simple. Why make it complicated? It should be, one should be in a position to easily understand what exactly you want to convey and what exactly anyone would have understood the terms. And that the terms of the contract must fulfill the ultimate requirement as well as due performance. Otherwise, the whole purpose will be lost. Therefore, you will have to take some extra care in formulating the terms of the contract. I would caution you that better, whenever a contract is being considered, it is in the anvil, please don't go in for a stereotype. Simply what called the cut and paste, that formula should be avoided. One may find it easy because it runs through several pages. One may find it easy to simply draw from the previous one and then do it. It is in that process many blunders are being committed. That should be avoided. We are there only to attend to that particular job. Why not we spend some time, apply our mind, go through each and every term of the contract and ensure that it specifically meets with the requirement and that there is no scope for any flaw in the application of it. Therefore, and that is one aspect of it. But in our anxiety to achieve the results, there should not be any term which would conflict with the laws. One may tend to say that there are frequent interference by the courts. Never. I would say in my experience, 16 years experience as a judge, whenever in commercial matters comes before us, especially arbitration awards, we take all precautions to see that we don't entertain any litigation. It is in rarest of rare cases where we found that there is a apparent blunder, mistake in the execution or some flaw committed. Interference is the least by the courts. Courts never creates hurdles. I want to make that very, very clear. In fact, on the other hand, the courts come for your rescue at the time of crisis, comes for the rescue. And courts do not create hurdles. There is one problem. That problem is not in the hands of the courts. The problem is shortage of judges. That is not the creation by the court. Therefore, the courts are not responsible for that. I tell you, in Western countries, they have 50 judges per million population. 50 judges per million population, whereas we have 8 judges per 10 million population. For we have to cope up with this workload. That in that process, some delay occurs. And definitely, courts never intend to create problems for the effective functioning of any working by anyone. See, in fact, in the laws, even the pre-independence era, when the Civil Procedure Code was drafted, Section 80 was put in. The purpose of it is to support you, to put you in advance notice that before any litigation is to be launched, 60 days notice is to be given to any state enterprise, so that the state enterprise can see to it if it can be solved, it can be settled, it can be resolved. Within that 60 days time, it should be completed, it should be concluded. instead of allowing the parties to go to court. Now section 89 has been introduced in 1987, where four modes of settlement have been suggested, and it has been made mandatory. And the Supreme Court in Afghan judgment in 2010, it has said that though the provision does not say it is parties should be directed to go for mediation or conciliation or arbitration, which the court has now interpreted, invoking Article 141 of the Constitution, that every party to the litigation, if there is scope for settlement, both parties can be compelled to go for one form or other of the process of dispute resolution, alternate dispute resolution. Therefore, there are now the law has also been suitably amended for quick, as Dr. Chaubey pointed out, Section 29A has now been introduced in the Arbitration Act. A time limit of 1 year has been fixed for any arbitration to be concluded, and maximum another 6 months, that too by getting an extension from the court alone it can be done. Therefore, there are very many aspects which are to be examined in this national seminar. I would, in my inaugural address, therefore, only request the participants to take effective participation in the national seminar, address all the we will call it hurdles or constraints, because the experts are there and they are very well versed in the field. Therefore, you can get the hurdles, constraints resolved through legal manner, and thereby make it more efficient, more effective in implementation, and with less scope for litigation, and also resolution of all the disputes in the best possible manner. With these few words, and while wishing the seminar, national seminar and the workshop to be very successful, I am very happy to inaugurate this national seminar, and I also thank the organizers, the chairman, Dr. Acharya, the Director General, Mr. Dr. Chaubey, for having given me this opportunity and for your patient hearing of my speech. Thank you very much, and Jai Hind.